Oyez, oyez, oyez. All persons having business before the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 22-3015, United States of America versus Joseph Smith, appellant. Mr. Zucker for the appellant, Mr. Goodhand for the appellee.
Good morning, counsel. Before we begin today, let me just note that today is Judge Garcia's first sitting as a member of this court. And on behalf of my colleagues, I just wish Judge Garcia a warm welcome to the court and many happy and fulfilling years of service in pursuit of our common calling. Welcome.
And congratulations from everybody. Jonathan Zucker and Patricia Dawson. May I can begin?
Please.
Thanks. Jonathan Zucker, Patricia Dawson, on behalf of appellant, request 5 minutes for rebuttal. I intend to address the jury selection issue and submit on the other issues on the briefs, and that's the only one I'm going to argue. And in all candor, I'm inclined to tell the court that Professor Chernoff's articles, which were cited, are essentially the argument I am adopting, and the arguments are made much more thoughtfully, persuasively by her in those articles. But the gist is of our position on the jury issue is recognizing the difference between the Sixth Amendment guarantee to a jury panel that fairly represents the community and the Equal Protection Clause analysis. The review in this case is de novo. It's a question of law. The court is well aware the three primary cases relied upon are Duren and Taylor, the Supreme Court cases that deal with jury panel representation, and there's three elements to the claim of this type. The first is that involves a distinctive group that is not fairly represented. Second, that the representation of the group in the panels, and it has nothing to do with the juries that are actually picked, but that the panels are not fair and reasonable in relation to the makeup of the community, and that the underrepresentation is due to a systemic or systematic exclusion. The first element of the government doesn't even argue, and the court found is satisfied. It has to do with black representation of the community within the panels. And I note there was some confusion, frankly, in the pleadings where it talked about black and Hispanic. But the testimony of both experts only had to do with representation of black members of the community within the panels. The second is whether the representation in the panels, the second is the statistical difference, whether that statistical difference between the census, which all the parties agreed was 39.3% black in the last census, and the representation of the panel, which was 24.9%. And I'm talking at this point only about the panel that was sent down for the trial. It was a differential of 14.4%. Subsequent to the trial and subsequent to the initial pleadings, additional expert testimony was taken and reports given, which broadened substantially to include other panels. And in each instance, there was still a discrepancy. There was still a underrepresentation of black members of the panels compared to the members of the community.
Let me ask you,
Sure.
an element you have not mentioned. Is it an element that the actual jury that sat on your client's case was underrepresented?
No, I think
Suppose, the hypothetical, suppose all 12 plus the 2 alternates were all black.
well, that's
Then
an
how can he claim a denial of jury of his peers?
Well, the claim is based upon the veneers that are sent down. The
I know
pools that are
that's your
sent down.
claim. What I'm asking you is, what if the panel that actually presided over the trial or was at the trial
With all due respect,
was
academically,
representative?
if the panel was all black, for the sake of argument, you still have the same issue. If, for the sake of argument, you sent down a panel of 100 potential jurors, 88 are white, 12, well, actually 12 would probably be closer to a representation, but you still have the infection of the panel, and you have to look at the panel.
How is that possible?
Because that, with all due respect, that's what the law is.
As I understand it, the actual jury here consisted of 5 blacks and, what, 7 whites? No, 5 blacks and let's see, 9 whites.
I don't remember the exact numbers, but again, the inquiry based on the precedent is you look at the panel, you look at the
Do
representation
you have
of
a
the panel.
case that stands for the proposition that the actual jury that sat on the case is irrelevant?
I don't think that's ever been addressed specifically.
I don't think
but I
so
know,
either, although in Justice White's opinion in, what was it, Duran? I've forgotten the name of it. Duran?
oh, Berger and something
He,
like that, yeah.
he made the point that the jury there was, and it was exclusion of women.
Right.
And the jury that sat on the case was 12 men. So do you think that was irrelevant for Justice White to mention that?
I can't comment on what Victor Justice White chooses to put into his opinion, but I think the standard is it doesn't even matter if the defendant is of the same race that's being questioned. I mean, in Taylor and in Duran, the issue was based on sex discrimination, that the panels did not fairly represent the community because women were being excluded at a disproportionate
While I
rate.
have you for the moment, let me ask you another question about why is the census a proper standard by which to measure? Let me tell you why I asked the question. Number one, in the District of Columbia, individuals who are imprisoned don't have a right to sit on a jury. Right? And number two, there is evidence as well, or not evidence, but there are statutes as well, that anybody in the District of Columbia who's been convicted of a felony cannot sit on a jury. So it shouldn't, the census doesn't take into account any of that.
I don't know that the census, I assume the census counts people who are convicted felons who would be excluded. I do not know whether or not the census includes
What is the
incarcerated people.
What is the rate of conviction in the District of Columbia of felonies for blacks and whites?
I do not know off the top of my head.
Suppose it's 50% for blacks, right? So the figure.
I want to make sure I understand your premise.
39% would not be representative at all, would it?
You're saying if 50% of the black residents of the District of Columbia were convicted of felonies,
Right.
that's a pretty amazing statistic, which
Oh,
I think
really?
which would
There's
skew.
a study indicating that it's an old study, but it's from 1997 by a prison research group saying exactly that.
Well, I still think that the experts in this case chose the census. The court didn't quibble about whether or not the census is the correct parameter to measure the composition of the jury challenge. So I think given the fact that both experts, the ones who were hired by the government and the defense, both chose the census as the representative sample, kind of ends the inquiry for our purposes. And the court accepted it. I don't think that was any factor in the court's decision. Did that answer your question?
Sorry?
Did that answer your question?
No.
All right. Do you want to rephrase it? I mean, you're asking me if...
You're making, when you reduce these numbers at 39.4%, et cetera, it sounds like you're engaging in a really exact science when in fact you're not. Because we really don't know what the number of eligible individuals in either race are available for jury duty.
I will concede that the census does not exclude. I assume the census does not exclude those who are disqualified based on prior convictions. But I think be that as it may, that's the standard the experts chose to apply, and that's what we have to measure the decision against. And so anyway, I think based on, well, the first element is already satisfied. It's not even in dispute. The second was this.
Counsel, could I just direct you to the third prong of Duran? So as you know, it requires
Systemic.
a showing that the cause is systemic exclusion, meaning something inherent to the process.
Right.
And as I understand it, your theory here is that response rates from the Black community were depressed because of the pandemic. And when the district court said is those are external factors. And I'm just wondering how we could characterize that as an inherent cause.
Well, first off, I'm not sure the pandemic played as large a role as was put forward in the pleadings by trial counsel or the plaintiff's expert. I think we have to look at what the statistics were, regardless of the pandemic.
But the data is from 6 to 7 months in 2021 during the pandemic, and that's the theory that was put forward in the district court.
Right. Well, I agree, but I think if there is underrepresentation based on either the pandemic or some other reason, we have to look at what the panels were versus what the population is and make a decision. Regardless, I'm just saying I don't think the pandemic even should play that factor in this case. And I think the trial judge, Uvell, found that there was what she called a non-trivial underrepresentation and that it wasn't a fluke. So I think we are left with her finding, which I don't challenge, that this wasn't an aberration. This wasn't she looked at both experts looked at several panels and said there is underrepresentation. They quibbled about the numbers and the percentages, but in any event, there was underrepresentation found. And once that's found, the question of whether or not it's systemic it's there, therefore it's systemic across the panel. I think the bigger issue where
Like what the argument you just laid out would reduce this to a two-prong test. The second prong is there underrepresentation? And your approach would be, then the government has to fix it. But I think we need to give some meaningful impact to what the Supreme Court set out as a third prong. And I'm just struggling with how your approach here does that.
You know, I think in some ways the second and third prong do mesh, that if there is underrepresentation, I think we have to infer it's systemic, and the absence of it being systemic is really up to the government to rebut. And I think what they've done here and what has been done by the trial judge and what has been done by numerous circuits is they've looked at this as, is there intentional discrimination, which shouldn't be a factor. The factor should be, if the panel does not represent the community, the panel does not represent the community, absent, trivial distinctions. And the whole, and I guess the point I'm trying to make.
What's supposed to happen then? Suppose that we're in a realm in which there is statistical underrepresentation. What's the jurisdiction supposed to do?
Fix it.
But how?
By adopting the measures suggested by Chernoff and I think Agors, by using a much more, requiring the jury office to send out follow-up notices. Those have been shown to the people who don't respond.
To everybody who doesn't respond?
Well, I don't think you could draw a distinction based on race, if that's
Okay.
your question.
So then, and then if it just, suppose that then there's still underrepresentation.
Well,
Because why would we think that, maybe there's something in the literature that answers this, but why would we think that response rates are going to be differential in a meaningful way the second time around versus the first time around?
I don't know that they will, but they've been shown to be effective. And so if there's a higher percentage of lack of a response among one group, then that is the group that's going to be, there's going to be a higher, you know what I'm trying to say. There's going to be a higher second request that impacts that group more directly because there is a lower response rate, and then hopefully that would correct it. Additional measures might be required. It might require the courts taking a more aggressive role, and I mean, right now, nothing happened to somebody that doesn't respond. And frankly, I was shocked in this case to find out that the response rate on jury summonses is really under 40%. And nothing happened. So the question is, if the court does something to enforce people's obligation to serve on juries, or at least to report, I think we could anticipate a more representative response. I mean, the response rate is much lower. I think it's 17% lower among Black residents than it is among, I don't know, white or other, however you want to characterize it. So that would be the focus of the second follow-up. And the court has an obligation to comply with the Sixth Amendment right to a jury that is representative of the community. It cannot excuse it saying, well, there's external factors. Those are frankly, don't comply with it. Those are just excuses and shouldn't be tolerated. The court has an obligation to pursue this.
So as long as there's a disparity, then that's, in your view, the end of the inquiry, then the jurisdiction just has to do something about it. That's the way you conceive of the three-pronged inquiry.
Well, I think if there's a reason for the disparity that is different, I mean, for instance, if the reason for the disparity is along the lines that Judge Randolph intimated, that there's a lot of people who don't respond because they know they're not qualified. I mean, that certainly would be a different explanation, and one if that turns out to be the case, one you can't correct, But until there's a finding that there is some other reason for this, what is, I suggest, systemic imbalance or difference.
Is the notification that goes out, or do you know, if the notification that goes out lists disqualifying circumstances so that an individual would not have to respond?
I could only tell you based on my memory of having gotten jury notices, because there was nothing in the court record about this. My memory is if you have an excuse, you have to put it in writing and submit it, and then usually you get I've never had to confront that issue as my excuse, but it's more of a scheduling issue. So I don't know the answer to your question.
Yeah, I raise that because, I've received jury duty notices from Montgomery
And I'm sure you've
County.
complied.
And I can disqualify myself because I'm over the age of 65. I just check a box and send it. But I still respond, I guess. That's
Right. Okay, so you'd be included in the response rate.
Yeah.
But here we have a response rate that is remarkably low and disproportionately low among one distinctive group. And that's what I suggest the court is obligated to address.
Let me make sure my colleagues don't have additional questions for you at this time. Thank you. We'll give you some time for rebuttal. Mr. Goodhand.
Good morning, Your Honors. May it please the Court, David Goodhand for the United States. With me at council table is Deputy Chief John Manarino and Trial Counsel Mona Sedke. If I could just address a couple of the questions that were raised to the best of my ability during my opponent's argument. First, as to the question of census versus juror eligibility, there is some debate in the case law about whether or not it's sufficient for a defendant to suggest just and reference just census data, or if there's an additional burden to go further and suggest, no, population is juror eligibility. I will and I would commend to the court if these are very complex issues, but as I was preparing for oral argument, I came across an authority that goes into great detail about a lot of these issues, and I would commend to the court if you're interested. It's Grand Jury Law and Practice by William Bryson and James Fellman, a very exhaustive review of a lot of the case law and a lot of the debates within this arena. All that said, with respect to the question of census versus juror eligibility as part of the prima facie case, number one, both parties agreed here that we were going to rest with the census data. So we're not suggesting that that was a prima facie part of his burden. Number two, I will note that the Supreme Court has indicated that census data, as long as we're talking about an adult population, obviously over 18, census data can suffice for purposes of the comparison that you're drawing. And I would draw the court's attention to the Duren decision where there is a discussion of the fact that census data was used there. Now, I will say that in Burgess, I think Justice Ginsburg makes reference to juror eligibility as the relevant benchmark. So even the Supreme Court is a little bit in between, I would suggest, on this question that has been raised. That's the first thing I wanted to draw the court's attention to. The second thing I want to draw the court's attention to is, I'm looking at the district court's opinion, a very thorough opinion on this topic, but I would just draw the court's attention to JA 277, where she decision, Picciarello. 536 F second 420. Another question I want to address that came up. The only thing we know, this gets back to the juror.
What does that prejudice in what sense?
I took
Are you suggesting that means the composition of the actual panel, or are you suggesting that goes to prejudice?
I took it to mean, and I apologize, I actually didn't do the deep dive into that case. I took it to mean that you can still bring a fair cross-section claim, even though the actual jury panel may or may not have reflected an underrepresentation. I may be wrong on that, but that's how I read that sentence, and I apologize. That wasn't a debate below, and that was something that everybody was kind of on the same page. And in fact, it was only the district court judge who brought out the actual, based on her observations, I think, the actual composition.
Do you know if the figures that are being used here apply as well to the Superior Court?
I do not. I know that there
Do you know
is.
if the Superior Court sends follow-up?
I do not know if they know. I apologize. I don't know if they use the one-step or the two-step. I can say this on the notion of follow-up. I heard my opponent suggest that should be a mandatory feature of the system. Well,
The other question I have is that the presentation by the defense here is not site-specific because he's dealing with the global question rather than what actually happened in his own trial. And so therefore, if we ruled in the defense favor, it would put in jeopardy, would it not, apart from the question whether an objection was made, but would put in jeopardy every single criminal trial that's gone on for the last, who knows, 10 years in the district.
well, I think that the defendant would have had to raise it, and that's sort of part and parcel of the whole jury statute, the selection statute, which is, at least on the statutory side of things, and I think the constitutional follows thereafter, you have to raise this, you have to claim either that your indictment was a problematic indictment because of the grand jury, or you have to stay the trial. That is, you have to say to the court, look, I think my pettit jury is a product of underrepresentation, and you have to stay the trial, continue the trial until we get this figured out and you can adjudicate that. So I think that those kind of preludes would have to happen before any sort of new trial could be ordered in any case that had unfolded with respect, for example, this master jury wheel or this summons list. That'd be my understanding of how that would have to operate. Very briefly, I would point out to the court the suggestion that there must be mandatory follow-up. The court actually addressed this, the district court that is, at least under the statute, and I'll cite to 28 USC 1864, it gives discretion, to the clerk, whether or not to summon non-respondents to appear to complete the form. And the district court noted, so this notion of mandatory enforcement, it actually would violate the statute, number one. Number two, that's sort of like what district court judges have the discretion to haul into court jurors who are summoned. They are on the report list, but they don't actually show up in the courtroom. Well, again, that's discretion for a district court judge. So this notion of mandatory enforcement would violate the statute. Second, it would, I think, we have to step back here and ask, what is the right we're talking about? As I understand the right, the fair cross-section right, it is not.
Can I just say, when you say would violate the statute, I take it if the statute wouldn't be violated across the board or violated at all necessarily, because it would only come into play, the notion of follow-up would only come into play in a situation in which you had a disparity.
Yeah, I think, yes.
So if the Constitution, by appellant's argument, requires the follow-up, then you're not taking the position that the statute forecloses that.
No. And I think that segues into my next point, which is, as I understand what the Constitution requires, it does not require complete proportionality. What it requires is that the system not cause or create underrepresentation. And that's the sort of core disagreement we have between the defense and the prosecution here. That is, nothing in this record demonstrates the system created an underrepresentation. What we have here demonstrated is a non-response rate of persons who get the summons, the questionnaire, and don't return it. That is, I would suggest, and the district court found, a sort of prototypical example of an external force. Those are the decisions of individuals who have gotten the summons / questionnaire, and they choose, for whatever reason, not to return it. That every court, as I understand it, and the district court said the same thing, every court has said that non-response is not something that is inherent in the system. The system thus did not create any underrepresentation. Of course, we don't concede that the second prong was met here. The district court concluded that.
Well, on the third prong, is that sort of a categorical position you would stake out, that anything related to response rates is always going to be external? Or does it have something to do with the particular facts here?
It's hard for me to conjure up, once you're talking about how a person who receives a summons responds to that summons, it's hard for me not to be categorical in suggesting that that is not something inherent in the system. We can, and the district court made this exact same point, we can debate as a policy matter what kind of things that a jury office might do, what kind of things a clerk's office might do. A second summons, a follow-up of some sort, but that is not constitutionally required. And I would also note that at least under the jury selection statute, they expressly the statute blesses this one-step process. So, the statute says we're okay with that and says, we're okay with discretion on enforcing the summons. And so the statute seems quite comfortable with the system that's in place here.
Can I direct your attention to the Fourth Amendment issue, and in particular, the sufficiency of the 2017 warrant?
Sure.
It strikes me that, at least on its face, the warrant, both in terms of the scope of the devices that could be seized and the data that could be taken from them, is essentially unlimited. And I'm wondering why, to start with the devices, clearly there was probable cause as to his phone, the computer, and maybe one or two other specific phones. Why shouldn't the warrant have specifically identified those devices rather than just saying any and all devices that we come across are going to be seized?
Well, I disagree with this notion of authorized everything, a seizure of everything, a search of everything. And critically, the warrant, I would suggest, has a global modifier, if you will. The evidence searched for, the paraphernalia, the contraband, the items seized must be evidence of offense in violation of 22 DC Code 3008.
But that limitation doesn't affect which electronic devices they were going to pick up, right? They seized 17 devices when they knew about 3 or 4.
Yes, yes.
It was not a meaningful limit from the statute as to the devices that they would go in and take out of this home without regard to who they belonged to or whether they even knew they existed before entering.
Well, I think that is a limitation, and I think Griffith speaks to this point. Griffith, of course, very different case, but Griffith, there was no probable cause to believe he even owned a phone, no probable cause to believe that he had a phone in his residence, no probable cause to believe that the phone contained any evidence of the crime. All that is different from what we have here. But what Griffith said is if you can establish a nexus, Griffith said if you can establish a nexus between the crime and the phone, then devices linked to the shooting was the phrase that Griffith used, and that's at page 1276. That would be permissible. And they talked, and Griffith, this court talked about one way that when you link a statute to a device is by officers, for example, could have examined a device initially thought might belong to Griffith, but they could not have seized the device if they became aware it belonged to his girlfriend. So that's one limitation here is if you go in and you figure out that the phone or the computer doesn't belong to the defendant, then you don't seize it. But getting back to the whole question of the phones that were seized, there were a number of phones that were seized, for sure. But that, I would suggest, was a natural consequence of the facts of this case. That is, here we had a year-long allegation of ongoing sexual abuse. Integral to that criminal conduct were the phones. At a minimum, 2 phones. The complaining witness's phone and the defendant's phone. So already we're talking about multiple phones. Added to that are further reasonable inferences, I would suggest. And again, we're talking about probable cause, but the further reasonable inferences are these. Even a citizen who isn't committing sexual abuse cycles through phones. You upgrade them, you lose them, you change phones. Add on to that the layer here of a defendant, a suspect, who is engaging in ongoing, regular sexual abuse of a minor. That person, I would suggest, it's a reasonable inference to conclude, might well cycle through phones a little faster and may spread out his indicia of guilt over a number of phones. I would suggest that an officer drafting this warrant would be remiss in a case of a year-long sexual conduct criminal offense to focus in on one phone.
Can I just ask on that score? So,
Sure.
as I recall, the suggestion was made that it could be cabined to 2 iPhones because the victim had identified 2 iPhones. And I don't remember exactly what her age was at the time that she had the exchange, but she was still pretty young.
Yeah, I believe 14.
14 at that time. And so it's at least, you'd have to rely on a 14-year-old's recollection of the particular type of phone. And am I right that there were iPhones that were mentioned, but then it was a Motorola phone that had?
Right.
And how, do you know what happened? Why was it not an iPhone? Why was it a Motorola phone that ends up with the bulk of the?
I have no idea, Your Honor. I don't think the record speaks to that. I think, if anything, it speaks to the inferences that I was just alluding
Right,
to.
that's what I'm wondering is, did we?
I don't think the record speaks to it. It speaks to what kind of common sense conclusions we can draw based on the activities of a computer savvy, a cell phone savvy criminal defendant.
I certainly appreciate those arguments as to the devices. I wondered if you might just very briefly address the scope of the data seized as well. And maybe the quickest way to get at that is, did draft this 2019 warrant that set out specific categories. The 2017 warrant doesn't have any limitation, and I think we can all imagine categories of information that might be on a cell phone, banking information, health information, that wouldn't really have a plausible connection to a crime like this.
I disagree with the notion that there was no limitation with relation to the electronic data. Again, I circle back to the global modifier. The data that was seized had to relate to the specific offense of first-degree child sexual abuse. Now, when you seize that phone, you have no idea, as an officer, where on that phone the data is going to be. Bass is a case where they talk about, we know, and it's fair to infer that manipulation of files, deletion of files, counterfeiting of files. So when an officer seizes a phone, and I would point to the Seventh Circuit decision in Bishop, goes into great detail about, if you link it to a statute, you can go through every file. And I would encourage the court to look at the Bishop decision that that Chief Judge Howell relied on quite heavily in her decision.
You say we don't have to decide any of this.
I'm saying that
Because of Leon.
Oh, well, sure. The good faith exception we would suggest is a backup argument for us. If it's easier for this court to go
It
down
doesn't
that
have to
road.
be a backup. It could be the.
It could be the primary argument.
Right.
And on that point, I see my time's out of, I will make one final point. Griffith did not find that the Leon exception had been met. Griffith, however, went to great pains to emphasize that there were 2 features of that case that were different, that were outcome determinative. Number 1, the missing probable cause, and number 2, the overbreadth. Here, missing from the equation is the absence of probable cause. District court found probable cause. My opponent hasn't challenged that ruling on appeal, and I understand why my opponent has not. The probable cause supported seizure of the phones, the seizure of the computers, and the electronic data, all of which was the global modifier relating to the specific offense of first-degree child sexual abuse.
Can I just ask one practical question? So the warrant describes the suspected evidence as consisting of a bunch of devices. And then it has the clause that you've been relying on where it says, which is evidence of an offense in violation of DC Code 22-3008. Is it the case that when law enforcement officers are executing a warrant framed in that way, that they understand the which is clause as cabining the stuff that comes before, that what they're looking for is information that's evidence of an offense in violation of DC code, so that if they see something on the device that by self-evidently has nothing to do with that, that's not going to be searched?
That's 100% my understanding. And it's not just, I would suggest, individual to law enforcement. I would suggest that that's common sense reading of that paragraph. That is, these are items that we believe we have probable cause to conclude are on the premises. You can only seize those items and look at that electronic evidence if it is evidence of an offense in violation of first-degree child sexual.
Right, but it doesn't necessarily follow that the search would have to be cabined.
Oh,
Because it already says that the device is evidence. So then
Sure,
you'd have to carry that through to say, and that's also cabining the way that I'm looking at the device.
that's how I read it, and I would suggest that's a common sense reading. It's that, conditioning global modifier that applies to everything that was seized, the devices and the data. Unless there are any further questions, we would ask that the court affirm the judgment and conviction. Thank you.
Thank you, Mr. Goodhand. Mr. Zucker, we'll give you back 3 minutes for rebuttal.
My colleague called my attention. I said Judge Huvero. I meant to say Judge Howell was the trial judge. I just misspoke. Regarding the probable cause in this case was for the 2 phones that were mentioned by the complainant, and everything was seized. So I would suggest the warrant simply went beyond, or the seizure went beyond. And to say that Leon establishes a good faith reliance when the executing officers knew that only 2 phones were mentioned is to create an exception that swallows the rule. The only thing I would point to, frankly, I'm trying to read my notes. Regarding opening up the lion's gate or the flood doors of every case that's been tried, I think it all to the same challenge. I have to agree with Mr. Goodhand that those doors have been closed because no other cases that I'm aware of have raised or preserved this issue. And frankly, I don't know that current panels have the same infirmity. Nobody's looked at it as far as I know. They may, in which case they may raise prospectively this same issue, but in my opinion, that would be a good thing because it would put pressure upon the jury office to correct what I suggest is this error, which is a Sixth Amendment violation.
You've been in the criminal defense business for quite some time, and I don't expect you to know this, but a memory is triggered by this discussion. And I think there was a movement in the District of Columbia Federal Court to expand the jury pool beyond the geographic confines of DC into the suburbs of Maryland and Virginia. Does that ring a bell?
No.
No.
All candor.
And I'm wondering.
You got a couple of years on me, Judge, but no, it doesn't.
The reason for, as I recall, was that they were running out of eligible jurors because people kept getting called and called and called again. But I don't know whatever happened to it, and I don't know whether there were any congressional hearings on it. Are you aware of any?
No, and I doesn't even ring a distant bell, in all candor.
Okay.
I am familiar with what you've said, that, when we were in the 90s going through juries left and right, that there was a resentment within the community about how often people were being called to serve. I do recall that distinctly.
Yeah.
But I don't recall anything about, let's go get jurors from Maryland or Virginia to address it. And I don't know what that would raise. Is there anything else the court wants me to respond to with it? I mean, I guess the bottom line I'm focusing on here is we cannot excuse the failure to comply with the Sixth Amendment requirement by looking at intent, which is really non-applicable. It's applicable in an equal protection context. It's not applicable in a Sixth Amendment context. And Duren supports, my recollection is Duren supports that, says we don't look at intent. We look at what the results are. Okay?
Thank you, counsel.
Anything
Thank you to
else?
both counsel. Mr. Zucker, you were appointed by the court to represent the appellant in this matter, and the court thanks you for your assistance. We'll take this case under submission.
Case number 22-5256, Robert M. Miller, appellant, versus Martin J. Gruenberg, chairman, and Federal Deposit Insurance Corporation. Mr. Tisa, amicus curiae for the appellant, Ms. Lyons for the appellees.
Good morning, counsel. Mr. Tisa, please proceed when you're ready.
Morning, Your Honors. Nathaniel Tisa as court-appointed amicus. With the court's permission, I'd like to reserve about 3 minutes for rebuttal. The CSRA requires that a federal employee who successfully challenges an adverse employment action before an administrative judge shall be granted interim relief. FDIC has conceded, both in its brief and its August 30 letter to the court, that Robert Miller is entitled to interim relief under the statute. It's even paid some of the amount that's owed. But this case is not moot. Mr. Miller vigorously disputes that FDIC has fully complied with its statutory obligations. And more importantly, this appeal is not moot because the district court's order denying relief is still in place. This court can rectify that by reversing the district court for erroneously withholding relief and remanding for a calculation of the amount that's owed. I'd like to.
Can you, the last point, when you said the appeal's not moot, what does it mean that the district court's order is still in place? Why does that prevent mootness from existing?
So the order is right now the law of the case, and the order holds that Mr. Miller is not entitled to any form of preliminary injunction. FDIC's compliance is entirely voluntary. Even though they've paid Mr. Miller some of the amount that may be owed under the statute, if this court were not to reverse the district court, FDIC doesn't have to continue complying. It doesn't have to resolve these disputes. It's under no court order to pay out the full amount that's owed under the statute.
If it had paid out the full amount, I mean, and I know you're an amicus, so I don't know, familiar with all the nuances, but if it has paid out the full amount, then does your argument still stand?
If there was absolutely no dispute about the amount that was owed, then you could look at mootness a little differently here. A single dollar of dispute is usually enough to keep a case alive.
Yeah.
If there was literally no dollar of dispute, then yes, that particular issue could be moot. But I do want to note as well that Mr. Miller has broader potential requests for preliminary injunctive relief that he made below that the district court did.
And which are?
So the preliminary injunction could have gone more broadly than the statute requires. The statute requires pay and benefits from the period between the AJ's decision and the MSPB's final. That's about 19 months. But a preliminary injunction issued under the court's equitable discretion could order ongoing payment until the case is resolved. It could also order different forms of non-monetary relief that Mr. Miller requested in his motion below.
And do you read the papers below to go to that extent?
We think if you look at Mr. Miller's motion, he basically bifurcates it into two requests. The first is for the court to comply with the statute, enforce the statute by providing interim relief. To remind the court, at the time he moved for interim relief, the MSPB had not yet issued a final decision, so that period was still kind of accruing. And then the second half of the motion asked for broader forms of preliminary injunctive relief. That included ongoing pay and several other additional non-monetary forms of relief.
Computer access and.
That's right, Your Honor.
Things like that.
Right, computer access to the FDIC's network, and an injunction prohibiting FDIC from doing certain investigatory and disciplinary actions.
So I have a question about the non-monetary relief. Putting aside, I understand the point, that's the monetary relief might not be moot if there's still a material dispute over the amounts. But in his motion below, this is page 334 of the appendix, he specifically limits it to until such time as the board or this court decides on defendant's petition for review. That, of course, hadn't happened when he made that motion when the district court ruled, but now it has. And so it seems to me that his request for the non-monetary relief by its terms has sort of expired. Is that something that, I don't mean to put you on the spot, but if that's something you've seen, I wonder if you have a response to that.
Your Honor, from my recollection of the motion, there were certain phrasings when it came to certain aspects of the relief. We also want to remind the court that Mr. Miller conceived of his appeal to the district court as an appeal rather than as a new case. So with the proper language under the statute would be that he filed a new civil case. But at times he referred to it as an appeal. At times he referred to it as a petition for review. The way we read the motion, at least, was that you could interpret the request to extend until the district court decided the case, decided his quote-unquote petition for review of the decisions that he was challenging.
Okay. Yeah, I think the concern is, so it actually relates to something else you said. When certainly the motion is divided into two parts, but in that second part, when he talks about, for example, the likelihood of success on the merits, my reading at least is that the only basis is still 7701. And what he's essentially doing in the preliminary injunction portion is trying to explain why he should be entitled to other types of relief, but he's still making clear that he's basing it on this statute. And so that sort of goes back to the first question. It would make sense for everything to be limited until the time that the board decided his appeal, because that's all that 7701 entitles him to. So that's kind of the concern I would have for mootness on the non-monetary relief. I wonder what the response is.
We think that when it comes to the monetary relief, the kind of most straightforward way to read the motion is he's asking for the court to order compliance with Section 771, like Your Honor mentioned. The non-monetary forms of relief certainly would be ongoing. We, at least, again, the way we read the request, return of his laptop, there's not really necessarily an end date on that. Access to the FDIC's network, no end date on that. And then the injunction kind of restraining the FDIC from investigating and disciplining on the same fact pattern wouldn't have an end date, at least not an end date tied to the MSPB's final order.
So looking past mootness for a second, can I just go to this question? So typically when you have a motion for a preliminary injunction, there's a prong that involves likelihood of success on the merits, and the likelihood of success on the merits is the merits of the underlying action that's brought. And here you have what appears to me to be a twist on that, because the likelihood of success on the merits, and I'm not trying to be too picky about exactly how we do this, and I understand the need to construe the filings in a way that's consistent with what we usually do in this context, but the merits all go to the merits of the request for interim relief under 7701, which is just not something that's part of the underlying action as styled in the complaint that was filed in the district court. So, and what we're reviewing now is the district court's denial of the preliminary injunction. That's what's before us in this appeal. And so how do we reverse the district court's denial of the preliminary injunction when what the district court had before it was an argument as to the merits of something that didn't relate to the underlying action? which is what you typically have in a PI case, it would be likelihood of success on the merits of the underlying action for discrimination, for a hostile work environment, for those kinds of things, none of which has been resolved yet ultimately on the merits. But the motion for interim relief / preliminary injunction introduces something new as to this action. It's something old as to the underlying MSPB proceedings and everything, I get that, but as to this action, it introduces something new because it's about interim relief under 7701, which just isn't in the complaint.
Your Honor, I think two responses to that. First, about the complaint itself, and then second, about the request for relief, the debate of this motion. So we think if you read the complaint, as Your Honor mentioned, kind of more liberally, because Mr. Miller is not a lawyer, he's a pro se litigant, we do think that he does press the issues that ended up forming the basis for the interim relief request in the preliminary injunction motion. The complaint walks through what happened leading up to the indefinite suspension, walks through the decision, and then makes the same allegations that he eventually relies on in the preliminary injunction motion. The allegation that FDIC was trying to kind of force him into foreclosure, trigger regulation that could render him ineligible. So all the bones were there.
But the relevant part is just what the ALJ, and in fact, I think the motion astutely says, don't look at any of the merits of the underlying stuff. Really, all you got to know is the ALJ gave me some relief, and then once the ALJ gave me some relief, there's an obligation to enter a interim relief, and now the FDIC actually agrees with that.
Right, so yes.
But I didn't see any of that in the underlying action.
So in the complaint, he does recount the proceedings that had happened up to that point. You know, you're right, he didn't frame a separate cause of action as a count, if you will, as maybe a person trained in the law would. We think that that's forgivable, or we hope that the court will kind of find it. It's hard to read it a little more liberally than it normally would. But to Your Honor's point about the fact that the AJ already found in his favor, we think that what Congress did here is they created a mandatory form of preliminary relief. They just took out some of the kind of normal equitable discretion the district court would have when examining this type of question, and provided very clear standards. If A, then B, right? If you have a prevailing party before an administrative judge, then he receives interim relief. Mr. Miller is the prevailing party, therefore he should receive interim relief. That's different than the normal kind of traditional equitable analysis that the court would do, but it is relatively simple, and we think that the complaint included all the pertinent facts and allegations.
But for us to reverse, then we'd have to say that the district court should have discerned that and then should have granted the relief. And as you helpfully point out in your reply brief, there's a motion pending in the district court to amend the complaint to include the count that would kind of tidy this up.
Yeah, so that's already been granted. That was granted actually quite a while ago. So the amended complaint, I think might have even since been another amended complaint, but Mr. Miller did go back and amend the complaint to include a separate count for the CSRA issue. So you could think of this also in terms of futility.
Was the motion to amend the complaint was granted before the appeal was taken?
No, it was granted after,
Okay.
so far as I know. But we think he did it out of an abundance of caution once it became clear that the FDIC could object on that ground.
So you have this argument about displacing the traditional equitable discretion, and I'd love to hear from you a little bit on that. But especially with this amended complaint, is anything at all stopping him from filing a motion for partial summary judgment if he's actually got a claim? Wouldn't raise that kind of question at all. It seems like the most straightforward procedural vehicle to get this kind of relief early in a case.
So Mr. Miller did argue at one point that the court could construe the motion for preliminary relief as a motion for summary judgment and kind of act on that basis. This probably could have been brought as a motion for partial summary judgment, but we also think it's appropriate as a motion for a preliminary injunction. We think that Congress just changed up the analysis and made a more focused preliminary injunction analysis required by the statute.
And remind me when if the argument was made that it could be treated as a motion for partial summary judgment rather than preliminary injunction, was that before the appeal or after?
So we certainly made it on appeal. We can definitely check and come back up and confirm for the court whether it was made specifically in the motions below. But we do know while he was briefing, you know, as a non-lawyer, he, in terms of the standards and the exact procedure, often kind of brought in multiple different types of procedures.
An interesting complication is that if it was construed as a summary judgment motion, we wouldn't have jurisdiction right now. And that's why maybe I was suggesting on remand, that would be a path forward. But just briefly on this argument about our equitable discretion, it seems to me, on my read of the cases you rely on, typically the statute speaks directly to courts' equitable authority and will say something like, the court will grant an injunction if. Whereas this statute creates a clear entitlement to relief, but it's directed at the administrative process. It doesn't talk about injunctions and vehicles for relief. And so, do I have that distinction right, and does it matter?
Your Honor, we have a few arguments. We think that the statute is best read to apply to the court under these circumstances. But just on your last point, you're right that the court would lack jurisdiction if this were a summary judgment motion at this stage. But we think that if you look at the structure of the statute and the legislative history that went into forming the interim relief requirement, it's very clear that this was supposed to be a preliminary form of relief. It's known as interim relief. The whole point is to give these employees ongoing pay and benefits while they're awaiting a decision. So resolving this case on the ground that it should have been a summary judgment motion would essentially defeat the entire purpose of the statute. If the motion is denied, then there's no interim relief, and it just becomes mooted. Now, on the mandatory point relative to the court, I think it's important to remember the 7701 and 7702 kind of relationship. So 7701 sets out a set of procedures for appealing as an administrative matter, an adverse employment action. And then 7702 says, if it's a mixed case and the agency doesn't act within a certain number of days, there's 3 enumerated timelines there, the employee is entitled to file civil action in the same manner as they could have filed under Title VII, the FSLA, the ADEA. If you look at the ADEA and the FSLA, they both include mandatory forms of relief as well. And this court and other circuits have held that explicitly. If there's a finding that there was a violation of the FSLA, then the court must order certain back pay and other types of damages that are enumerated in the statute. The statutory text says that interim relief shall be granted. So it's framed in language of direction, not discretion. And it's also framed in the passive voice. It doesn't say shall be granted by anyone in particular. And we think that leaves open the possibility that in this type of mixed case, where instead of being resolved in the administrative process, it's gone to the district court, it may be district court's responsibility to enforce what the statute requires.
Make sure my colleagues don't have additional questions at this time, and we'll give you a little bit of time for rebuttal. Thank you. Ms. Lyons, we'll hear from you now.
You hear me now?
I think so, yeah.
All right. Good morning, and may it please the court. I am Jane Lyons from the U.S. Attorney's Office on behalf of the chair of the FDIC and the FDIC itself.
Could you might want to lower that just a little bit more. It might come through a little better, yeah.
Am I actually that short? I am. I am that short. I think understanding how we got here and where we are shows the way forward for this court. In August of 2022, when the district court denied the preliminary injunction request, interim relief, Miller had been on indefinite and conditional suspension from his job for 2 years because he had sparked concerns in January 2020 about whether he posed a potential threat to the safety of himself or agency personnel, and he had not found a way to assuage those concerns. Miller had prevailed in part in an initial decision rendered by an administrative judge at the Merit Systems Protection Board, who found preliminarily that the FDIC should have ended Miller's suspension in April of 2021. The administrative judge did not address interim relief, despite an board regulation requiring her to do so. The FDIC filed a petition for review of the interim decision and asked the full board to review that interim initial decision. The agency had a reasonable belief at that time that it didn't owe Miller any interim relief because it was unclear in the silence of the statute and the silence of the regulations what it meant if the initial decision did not address interim relief. On May 16, 2023, well after the district court ruled, the Merit Systems Protection Board issued a final order which affirmed that the indefinite suspension was properly imposed, and it reversed the finding that the suspension should have been lifted in April of 2021. This deprived Miller of his status as a prevailing party at all in those administrative proceedings. But under a newly announced interpretation of the statute, on the same day, in a case called Stewart versus the Department of Transportation, the board also found that its own administrative judge's error in not addressing interim relief in the initial decision rendered Miller eligible for interim relief by operation of the statute.
Right, and then at that point, it's clear that Mr. Miller's entitled to interim relief too, and the FDIC says so, and then a payment is made. And can you just tell me, is the government taking the position that the appeal is moot? Because your brief, which was before the payment was made, your brief says something like almost moot or largely moot or mostly moot, and then it says almost everything or virtually everything's decided. Of course, if it's only virtually, then it's not moot. And the only potentially material thing that's happened since, as far as I know, is that there was a direct deposit. I assume it was a direct deposit that was made. And Mr. Miller, I think, has indicated to us that he's trying to figure out whether the amounts are right. And so we don't know yet that there's actually an agreement, and there may well not be on the amounts. Given that, is the government taking the position that the appeal is moot?
Yes, the government is taking the position that the appeal is moot, but let me explain a couple of more things that are relative in the factual scenario that you currently laid out. There's more to it. In the final decision, the board anticipated the possibility that there would be a disagreement with the parties about the math. And as I stand here this morning, Your Honor, my most current information from the agency is that it is still working with the thrift savings plan and its 401k provider, it's T. Rowe Price, to calculate the correct amounts of breakage and other things for contributions to Mr. Miller's retirement accounts. That is an ongoing process, as far as I understand it. There are third parties involved. There is a new, Mr. Miller, as I understand it, has initiated a new MSPB appeal, and those issues are being dealt with in a separate administrative proceeding, and there is still another administrative proceeding ongoing before the Merit Systems Protection Board about the status of the suspension after April of 2021. That is all still ongoing. There's a hearing scheduled in the case about the ongoing suspension. There's a hearing scheduled for October 25th.
This is an appeal from the May 16th ruling?
There is no, this case,
No, the other actions.
no, I would not say that is correct. I would say that the final order on May 16th is something that could be the subject of a supplemental complaint in the district court.
Well, he
Now
filed a motion to amend within 30 days. Is that this separate action?
that could concern a separate claim. I think the question for the district court is going to be, in its case management prerogative, when to start reviewing the MSPB's final orders, because the court is well aware, the district court may only review the final orders. Our focus today is on the interim relief.
But isn't there an argument that it's not a final order because it was referred to the regional office?
With due respect, Judge Randolph, I don't think so. I think it is a final order on what was before it at the time. It's important to understand what the Merit Systems Protection Board decided was that its administrative judge had made yet another error by considering things that the parties had not briefed and put before it. There had been a procedural error about who was on fair notice of what would be considered in those proceedings. I think the proceedings are closed, but there are ongoing proceedings over the disputes regarding the suspension. And if I could say a word about the nature of that claim, which is what underlies this request for interim relief. The nature of that claim is one of mandamus. If you're going to go and construe the complaint as broadly as you can, as your questions were suggesting, Chief Judge, that nature of that claim is really one for mandamus because the statute doesn't say who or when or what, who's going to resolve disagreements about it. So it is in the nature of, I have a right, and I've come into court to enforce it through a preliminary injunction on what is essentially a mandamus request. It's extraordinary relief on extraordinary relief, is part of my point there.
Is it, the preliminary injunction, apart from the back pay, is basically saying, this is what I get from it anyway, saying that the error was in indefinitely suspending me. And I'm going to get that overturned. And in the interim, what I'd like to do is have my computer back or whatever.
I think part of what I was hearing developing a little bit in the argument before I got up with my friend on the other side was a notion that there's a difference between the pay and interim relief and the forms of other relief that he sought besides money, non-monetary relief, like his access to the computer system, his laptop, being free of any more requests for medical information. Those are all forms of the interim relief that he sought, and was all predicated on the interim relief statute. The interim relief statute, let's be honest, what it is it's a form of temporary relief similar to restoring the employment.
Okay, I missed that point. And so you're saying that all other than back pay, that the other things that he's seeking were based on the interim relief statute?
Yes, Your Honor. That's
not on general principles of preliminary injunction?
No. The way he presented the argument to the district court was that it was all incumbent as part of the interim relief. And I don't really have any criticism of that approach by him, to be honest. The interim relief statute goes beyond the payment of just money, and it encompasses a sort of a restoration of the employment relationship to a degree for the time during the MSPB's proceedings. But there are exceptions. It's not an absolute right. And because there are exceptions,
is this a disruption?
Disruption to the workplace is one of them. And obviously, the FDIC never got a chance to invoke that or litigate that before the board because its administrative judge didn't do the job quite right.
Right. Okay.
So
clear as mud.
It's clear as mud. Every mixed case I've ever been before the court on felt much that way. This one is particularly a bit of a interesting one to me because the agency has paid the money because it is here this morning to vindicate the importance of safety in the workplace instead of money.
It raises another question that hasn't been addressed, and that is, as I understand it, if you don't get a ruling in how many days?
120, I believe.
120, you can go to the EEOC, or you can go to the Court of Appeals, or you can go to the district court, depending on all that. But then what happened, the question that's raised is what happens if on the 121st day, the agency comes out with a ruling?
Well,
because it's a review of administrative action.
Right. So what happens in a mixed case that comes into the district court timely under that statute, but a little bit untimely because the board hasn't finished its work, typically the district court faces having to have, for lack of a better term, sort of bifurcated proceedings. It can go ahead on the de novo claims and do what it would normally do. And then it has to wait for the final board decision so that it can have an administrative record and ultimately review those decisions under the Administrative Procedure Act. But until there is a final board decision, that part of the case isn't ready for review. What is, to me, sort of odd about all that is that you're in court and they're just two different things going on. And this case is not just a mixed case. Mr. Miller also had an individual right of appeal action that the MSPB rejected. That's the whistleblower thing that could go to the federal circuit. May have, for all I know. But it's particularly confusing here. But the agency has complied with the statute and removed the basis for any kind of even claim for irreparable harm. And our position is very much so that the statute does not displace the traditional test that is to be applied in injunctive proceedings.
Counsel, can you address again why the monetary relief request is fully moot now instead of largely moot. In particular, what you just suggested certainly seems relevant to me, that the fact that a payment has been made might be relevant to how we think about irreparable harm. But where he's saying this payment is not sufficient, there's still a lot of details to be worked out. How does that actually render the case moot when we could issue an order that you're actually required to pay a full amount and have that overseen by a court?
The answer to that, Your Honor, is in Bieberman versus Blinken, which instructed that not only this court, but the district court as well, courts shouldn't issue orders to pay interim relief because the basis of the claim is an Administrative Procedure Act type of review, and instructing the Merit Systems Protection Board, perhaps, or the agency to reconsider would be the absolute outer limit of the authority. Here, there's no need to exercise that authority because there are already ongoing administrative proceedings to address these issues, and then they will be subject to judicial review once those are final.
But why, that's not a merits disposition? The case that you cited,
Well, I'm sorry, Your Honor.
if the case that you cited,
Bieberman versus Blinken.
if it stands for the proposition that it's wrong to enter an order requiring the transfer of money in this context, that the range of remedies is something limited, more constrained than that, that results in mootness, or that results in the claim for interim relief failing on the merits?
I would like to say both. So Bieberman versus Blinken is a case interpreting a very similar interim relief statute for the Foreign Service Grievance Board. So similar system of personnel review, similar statute, and the court was asked to provide interim relief, and the court held that interim relief was inappropriate. As part of that, it addressed the nature of the claim and the nature of the judicial review of that. But getting to your question on sort of whether any lingering dispute over the dollars and cents renders the case moot, the case is moot because the agency has taken the substantial steps of complying with the statute, and there's no question that it will continue to do so. And we think—
Does it matter that the agency tendered a payment at all? Suppose the payment hadn't happened yet. Would you be in the same position because there's still a dispute as to the payment amount?
We would be in a weaker position, perhaps, if the agency had not yet made a substantial payment.
Okay, suppose the agency pays half and says half is coming, the second half is coming. Is that the same situation we're in now?
I think because courts ordinarily presume that agencies will follow the law and they will act in accordance with their announced intentions to follow through, that would be a situation where the court should find moot.
Then that would be true even before they paid anything because the FDIC had already represented that the payment was going to be made.
I think that's probably true. I think we were a little weaker in our brief than we probably should be. Looking back, when I prepared for argument, I wish we had been clearer and stronger on the mootness argument.
My colleagues don't have additional questions for you, Ms. Lyons. Thank you, Ms. Lyons. Your TISA will give you 3 minutes for rebuttal.
Thank you, Your Honor. Well, hopefully we can clear up some of the mud on the mootness issue. And then, Judge Garcia, I have a response to some of the questions you asked earlier about the PI motion itself. So on mootness here, this case it just isn't. If you look at the way that the jurisdiction works here, once the agency doesn't render a decision within the statutory time frame, and the employee decides to file a civil case, that court has jurisdiction. It's not required to wait for any administrative proceedings to continue. Essentially, the administrative proceedings become irrelevant. Jurisdiction vested in the district court. It can review the claims de novo and proceed as it would under any of the statutes that are cross-related to the CSRA. In terms of the mootness of the requests here, Judge Garcia, if you look at A290—
In terms of what, I didn't hear you.
the mootness of the— raise this a little bit. The mootness of the preliminary injunction requests, if you look at A291 to 292, the requested relief here isn't bound to the scope of statutory interim relief. So we respectfully disagree with my friend on the other side on that point. Mr. Miller requested interim relief starting on the date of the AJ's decision, but if you look at the motion, it doesn't expire upon the completion of a
Do you
final
have your
decision.
brief, your topside brief before you?
Yes, Your Honor.
Okay. Could you turn to page 48? I'm looking at the second full paragraph there. And the way I read that is that the agency can comply with the ALJ's order either by reinstating Miller or by restoring Miller's pay and benefits without duties because of undue disruption. That choice, the agency's choice, is effectively unreviewable. Miller has no inherent claim to government property not offered as a payment. Now, the way I read that is if he gets his back pay, that's in compliance, that's fine. But these other things he's asking for, the agency can deny, that's unreviewable, end of story. Have you changed your view on that?
No, Your Honor. So in terms of mootness, the case is live if there's any potential for relief. This court and the Supreme Court have made that clear case after case. If there's even $1 of disputed value or any potential for remedy, the case is live for constitutional mootness purposes. What we said—
I've been unreviewable.
Well, effectively unreviewable in the sense that there's not an ordinary kind of arbitrary and capricious standard that would apply to the agency's decision of whether to return the employee to duty or simply
What is
provide.
the standard?
So from what we understand, and this, if you look at the statute, there's two options for compliance. The agency can pay the employee and return the employee to work, or simply pay the employee and then not return the employee to work by making that undue disruption determination. So that determination is something the Federal Circuit has said the agency has, I think the phrasing they used was effectively unreviewable discretion to make. The employee is whole either way. The employee is getting the pay and benefits. So whether the agency wants the benefits of the employee's labor is up to the agency. Here, the FDIC has done neither, right? They haven't returned Mr. Miller to work, and they also haven't restored his pay and benefits during the statutory period that they should have. So if there's no further questions, we think the most straightforward way to resolve this case would be to reverse the district court's order and remand for a calculation of what's still owed under the statutory interim relief requirement. Thank you.
Thank you, counsel. Thank you to both counsel. Mr. Tisa, you were appointed by the court to assist the court in this matter, and we thank you for your assistance.
Case number 22-1310 et al. T-Mobile USA Inc. petitioner versus National Labor Relations Board. Mr. Harris for the petitioner, Mr. Lauro for the respondent.
Good morning, counsel. Mr. Harris, please proceed when you're ready.
Thank you, Your Honor. May it please the court, my name is Mark Harris and I represent T-Mobile. This case concerns the definition of a labor organization under Section 2.5 of the NLRA. The NLRB initially held that since T-Voice as a whole did not adopt or endorse any of the proposals at issue here, couldn't be group proposals. Because they weren't group proposals, T-Voice was not a labor organization. On remand, the board changed its position and held that whenever a T-Voice representative makes a proposal on a representative basis, that somehow automatically becomes a group proposal, whether or not T-Voice plays any role in the process. The board's decision is incorrect for a number of reasons. First, it violated the board's long-established precedent about the meaning of group proposals. Second, the board's finding of a pattern and practice of dealing was wrong and lacked substantial evidence. And third, the disestablishment remedy was arbitrary.
Can I start with the first one? So in our opinion, that resulted in the remand that you referenced, we said on page 663 in the Federal Reporter version, the court is left uncertain about what the record must show for the board to find that an organization made group proposals as opposed to engaging in mere brainstorming. Is it enough that an employee representative makes a proposal while acting in a representative capacity? That standard is suggested by the result in Dillon Stores. And is that not what the board did on remand?
No, it didn't, Your Honor. This is really a crucial point in our argument. The court, as Your Honor just stated, set this out as a line of cases, majority of cases, holding that group proposals were required. And then Dillon Stores, on the other hand, seemed to suggest that group proposals were not required. What the board did on remand was the board decided that representative proposals are group proposals.
Right, so I get that. I mean, the way the board framed its decision is to say that representative proposals are enough and we're going to deem them to be group proposals. But let's just forget that last part just for now. And I know that's the linchpin of your argument. But let's just, if that's just, putting the gift wrapping paper on the package, as I understand it, was to do exactly what we said was possible, which is to say that an employee representative makes a proposal while acting in a representative capacity, then that's enough. And then the organization can be deemed a labor organization. And so why does it matter that they framed it as that being a group proposal, whatever that means? What matters is the content of it. And the content is what we said, which is that, is it enough that an employee representative makes a proposal while acting in a representative capacity? Yes.
Well, I think it matters for a few reasons. The most basic one is that the agency obviously has to give a reasoned explanation of its precedents. I don't think it can just call anything a proposal that it isn't one. But going more specifically to your point, I don't think it's an accident that the board chose to use the group proposals rubric. I think the reason the board did that, didn't go with what this court set out as being its interpretation of Dillon Stores. And you run into big problems. What you say is that there's a Dillon Stores option, which is that there doesn't have to be proposals at all. One problem is, how do you tell the difference between an individual proposal and a group proposal? I don't think this court meant to say in the previous decision that it was approving of Dillon Stores as a correct interpretation or being consistent with its own precedent. I think the court simply said we've identified this line of cases and this other option. We would suggest that if you, under the Dillon Stores interpretation, the problem you have is what's happening here that makes this something which is a bilateral dealing between T-Voice as a whole and T-Mobile. For example, the main example that the board brings up is one instance where a woman named Dominique Jones made what they consider to be a proposal on behalf of her group, which was called the Dedicated Care Department. The board wants to then say
That's the dual monitors?
Yes,
Yeah.
Your Honor. The board wants to say that somehow that should be attributed to T-Voice as a whole. The problem with that is that that would mean that any one individual T-Rep, and there are hundreds of T-Voice reps, any one of them could somehow turn the organization into a labor organization simply by making a proposal in the name of her constituents, let's call them. Very hard to understand how that makes any sense. The board also did something very interesting here, which is a second level of complexity. The board did not just say that any type of proposal made by a rep counts as a group proposal or as a proposal that labor organization. There are three possibilities of what a representative could do. A representative could make a proposal in her own name. Take Dominique Jones as an example. She could make it in the name of her constituents, or she could pass along one of their proposals. The board says that only one of those creates a group proposal. If the representative simply says, this is what I think this is a good idea, I'm speaking for myself, I work at this company. The Polaroid case says that won't work. That does not make a group proposal. That's out. If the representative says, I'm going to just pass along something that I heard from one of my representatives, I'm just putting it into the system the way that the overwhelming majority of these proposals got made through the SharePoint system, unedited, unscreened, just here they are, here's the proposal, take it. That also, under the EFCO decision, would not be enough to create a labor organization, although the board here equivocates a little bit on whether or not it would come out that way, but they don't rely on that. So they're saying the only scenario here where there's a group proposal is if a T-voice rep, acting as a T-voice rep, speaking on behalf of constituents, makes a proposal, then it's a group proposal. I would suggest this is a completely unworkable system. This would mean before you could ever figure out whether or not an entity was a labor organization, you'd have to inquire into the origin of the proposal. Where did it come from? Is it
So counsel, I think I could imagine hypotheticals where those lines are difficult to draw. I'm struggling with why it's difficult here. And in particular, I wonder how you would ask us to think about T-Mobile's own statements, right? So Dominique Jones makes a request. First of all, it's on behalf of her entire group. So that might be one piece of evidence that it's a representative capacity. But after the fact, T-Mobile turns around, and I don't have the quote in front of me, but essentially says, T-Voice made this happen. T-Voice is doing a good job for you. And so in that kind of a situation where it's clear, it seems like that's a basis for the board to say, look, everyone understands that the individual was acting in her role as part of T-Voice and was credited for acting in that role. And in that situation, it seems like the line is pretty easy to draw.
Well, the board did cite that evidence, but that was not the only basis on which the board came to this conclusion that she was acting in a representative capacity. The board at length went through each of these 6 examples and actually tried to go through and explain what was the origin of the proposal, where did it come from, why was it made. The Dominique Jones example, I'll concede, is a little bit clearer that she was speaking on behalf, trying to speak on behalf of her group. The other 5 examples, though, it's not clear at all. If you look at what the NLRB actually said in the remand decision, they based their conclusion on things like, well, there's an entry in the system and the entry uses this person's name. We're going to then just assume that if it's in the name, the T-Voice rep listed her own name, we're going to assume then she wasn't passing along somebody else's suggestion. We're going to assume it was hers. The problem was that the record wasn't developed for that purpose in mind at all, right? The record was developed in the first case when the board took the position that this was not a labor organization. Those conclusions just simply don't follow. There's another level of this which is also problematic in the board's findings, which is that the board reversed its findings on 5 out of those 6 examples. So put aside Dominique Jones again for a minute. The other 5 were situations that came up during these national conventions. One of those cases, the board initially said, this was the example involving performance metrics. The board initially said, there was no response by management. That was actually a finding that the board made. On remand, the board said, well, it doesn't really have to decide whether or not T-Mobile, whether it accepts this or not. It just has to contemplate it. That's not the standard. The standard, as the board has said many times, that there has to be acceptance or rejection in word or in deed.
Before you go any further, I'm just wondering whether all of this is a red herring. Because if I look at the statute says that the committee, or whatever it is, the organization, exists for the purpose, in whole or in part, of dealing with employers concerning grievances, et cetera. Exists for the purpose, in whole or in part. Isn't the first thing that you would have to look at is what the charter is for T-Voice? Why was it established? If it exists for the purpose of a couple examples that don't conform to the purpose, proves nothing.
So
and the charter is on page what is it, 761 of the appendix. That's the charter?
I
Right.
believe that's the charter, Your Honor. What the board has done consistently, there are lines of, I guess there were sort of two lines of
And let me finish one other
Sure.
thought that I have, is that the law has a doctrine to take care of situations like you're describing, and it's called de minimis non curat lex, right? What is it, 3,000 different complaints or whatever from customers, and then 6 possible instances in which the employer or employee talks about employee stuff?
I completely agree. It really was de minimis. That's what the dissenting member of the board felt. And this is reinforced by the fact that we're literally now 7 years later. And the board makes this pretty extraordinary statement in the brief that there are lingering effects of whatever was what they think was the original composition or purpose or functioning of T-Voice. It's hard to imagine how there could be any lingering effects whatsoever this many years later. In fact, I'll go even further. On the theory that an individual T-Voice rep, by making a proposal, can somehow now turn the overall organization into a labor organization, that would mean then that 7 years later, we're supposed to, the board should be taking into account what one person did who's long gone, because their terms were 6 or 9 months. So the board has now said, effectively, one person did something 7 years later, after the company has disclaimed that that's the purpose of it, after the board itself has found that there were no further employee pain points being contemplated past February 2016, based on what one person did, or a handful of people did, that the correct result is disestablishment. That's very, very hard to understand how that could be.
In the charter, it refers to, there are a lot of acronyms here, but one of the things that sticks out is that it seems to be dealing exclusively with customers and the relationship between customers and frontline. Who is frontline?
Frontline are the customer service representatives who deal with the customers.
So this is all about the relationship between customers and frontline people. That's the charter. And I don't see how 6 instances over involving, compared with 3,000, changes that purpose of the charter.
I agree.
Did you raise a purpose argument? I thought you were talking about dealing it.
So it's all folded in together. The standard is that the group exists at least in part for the purpose of dealing with the employer. The question is, does the purpose of dealing with, is that judged by what actually happens, which is what some court cases say, or is it judged by sort of documents that would say what the purpose is? What the court has often said is, we look at what actually happens. They did rely on statements from T-Mobile, from the employer, but they also, as I said, they went through in excruciating detail to talk about these examples as if the examples mattered. So that was the decision, that was the basis the board gave for its decision. I want to just mention one more thing, Judge
Can I
Randolph.
just very briefly ask about how you're reading the charter? Just a question. So I think clearly one part is work on how CSRs work with customers. The second sentence here is provide a vehicle for frontline feedback. So vehicle for CSR feedback, and create a closed-loop communication with T-Mobile's senior leadership team. I think the way the board construes that is it's telling all the potentially represented employees, this is your route for raising issues and getting them addressed by management. Why is that wrong?
I don't think that's what it meant. If this was really the vehicle for the frontline, the CSRs to complain about their jobs or talk about terms and conditions of their job, I don't think you'd have only 6 examples. You'd have many, many, many examples out of thousands of them. I think the point is, the board actually, I think, the board deals with this in an unpersuasive manner. The board wants to argue now that, well, anytime you're dealing with how customers interact with the company, well, that automatically implicates employee issues because they're the ones who have to deal with it. That can't be the standard. That's the way they get around one of their factual findings, the one that I just mentioned, which was that,
Can I follow up on that? The example that is the prime example of it getting dual screens. Why isn't that a customer enhancement thing? Because it enables the frontline people to better handle customer complaints.
It is, Your Honor.
Did you argue that? Was that argued by the employer?
I don't think it was argued explicitly that way below. So we haven't pushed that on appeal here, but it's definitely, to answer the question, each of these examples.
But I could see a lot of situations in which a customer service representative is going to come to management and say, the best way I can deal with customers is if you change my terms and conditions so that I can do the following.
Right, but I don't think we have examples of that.
But if that were the case, then would you say that that's not germane to whether the organization is acting as a labor organization? Because they're still talking about terms and conditions.
No, I think if it were explicitly terms and conditions of the sort that I would do a better job if I had an extra hour off every day.
Right.
That would be a term and condition.
I'd serve the customers better if I had an extra. Right.
Correct. But
That would
these were
just
all,
be.
yes, but these are all much more closely tied to the customer.
Can I ask you on this? This is just, I just don't know the answer to this, and it may well be explored, but what's the reference to internal and external customers? So what is that? Who are the internal customers?
I'm not sure, Your Honor.
I guess where I'm obviously going is if it's internal customers, that's how you raise stuff that matters to you as opposed to the external customers who buy our product, then
Right.
would that mean that by mission and objectives, by identifying, discussing, and communicating solutions for roadblocks for internal and external customers, are they?
I'm not sure what that means.
I see.
The one thing I just want to come back to.
I can offer a hypothetical because I wondered about the same. And the way I took it was that an internal customer is an existing customer and an external customer is a potential customer. And the front line deals with both.
It may be. The only thing I want to say about this point before I sit down is just that these were not the rationales on which the board rendered the decision. I understand the court's asking the question anyway, but that's the decision. It based its decision on those examples and on a few generic statements that the company made, not even the charter. Thank you, Your Honor.
Okay, thank you, Mr. Harris. We'll give you some time for rebuttal. Mr. Laro, hear from you now.
Good morning, Your Honors. May it please the court, I am Greg Laro for the National Labor Relations Board. If Your Honors would like, I would like to start with the issue of the board's determination that proposals made by individual members of a group acting in a representative capacity count as a group proposal for the purpose of assessing dealing in a labor organization. I know you discussed that this morning. Not to recap too much, but in remanding, the court acknowledged that the board can have a group proposal requirement, but that the board's assumption that individual proposals didn't qualify potentially ran counter to some precedent, and as well as the board's observation that under the Act, informal organizations, that is ones that don't necessarily have a formal mechanism for adopting as well. And in answering the court's question, would individual proposals suffice? The board answered that in the affirmative. It looked at the text of the Act and the legislative case law, including that which the court cited, and came to a reasonable conclusion consistent with the Act itself that yes, proposals by individual group members acting in a representative capacity do suffice as group proposals. And I'm happy to answer any questions.
Why? So it's true, I think, that we didn't conceive, in our opinion, of those individual proposals as being group proposals. That's the board added that, and maybe with good reason the board added that. But I didn't read our decision to contemplate that those would be considered group proposals. They still might be enough to render the organization a labor organization.
Right. And that is the key point, whether it's a labor organization. As to, I believe you called it packaging as opposed to the contents, the board came in its first decision saying, we have a proposal requirement. And I view the court as saying, that alone is fine, but what about this issue of individual members being proposals? And the board said,
Can you talk a
yes.
little louder, please?
Yes, sir?
Can you talk a little louder?
Oh, I'm sorry. Can you hear me now?
Yeah, if you speak
That's
directly to
great.
the mic, it's a lot better.
I
yeah.
will lean in. Thank you. Thank you.
Right, so you were saying about the addition of group proposals, which appears to be an add-on to the way we described the Dillon store end of the spectrum.
Right. I view it, as I was saying, as the board coming in pre-remand with a group proposal requirement, and the court saying, we understand that you cite some cases for that, DuPont, EFCO, those four, but the court observed specifically that none of them say, none of them hold that it's not a group proposal requirement, or if you prefer, sufficient for dealing, where individual members of the group make proposals while acting in a representative capacity. And what's interesting about that is my opponent says, well, we have those four same cases. Why don't we just return to that approach and those cases? That's exactly what led to the remand. The court said those cases don't answer the question adequately. They leave it open and potentially conflict with cases like Dillon. And again, the idea that an informal structure can suffice. But at the end of the day, the question before the court is whether the board's view is reasonable and consistent with precedent in the act. And the answer is it is. And I think just pointing to those four cases, saying the board departed from that isn't sufficient because the court explained those cases don't answer the question. They don't hold that individual proposals don't suffice. And I think the board then applied that standard. And one thing I want to get out of the way is my opponent suggested that the board switched from the first time switched from the first time on some specific factual findings. What actually happened was the first time the board is saying these aren't group proposals, and that's essentially the end of the analysis. And because of that, it actually drops a footnote. This is footnote 21 of the first decision saying, because we find these are not group proposals, therefore under our framework, you don't have dealing in a labor organization, we don't need to address whether these proposals involve statutory conditions. We don't need to get there. So when my opponent says, well, it switched as to that, it didn't. I acknowledge there's one instance where I can't recall, frankly, just a factual recitation in the first case. The board noted there was one proposal. You may recall the one about metrics at the 2015 summit, where Tolman, the head of T-Voice, said, I don't think there was any follow-up. That's what the board said the first time. But the record actually shows she just said she didn't follow up. And this time the board noted additional evidence where multiple managers forwarded the proposal in question for consideration. So I'm just saying the board this time properly considered all the record evidence. Last time it was focused on a group proposal. I just don't see this contradiction or 180.
Can you address these questions about the charter? Because as I read it, the board does cite the charter, and it interprets it as a statement that T-Voice is going to represent the frontline workers in dealing with management, and that probably that plays a big role in somehow finding that 6 instances is enough out of the thousands. But I think a question has been raised about whether the board is reading that charter correctly. So can you address that?
I think Your Honor's statement is absolutely right. The board is reading the charter as indicating that T-Voice representatives, they're called representatives, will represent other employees. And frankly, I don't think their representative status is disputed here. As to the charter, it clearly says, and you discussed it this morning, that it can raise both customer
You have
and
to speak
frontline-
louder.
Sorry,
Speak into the mic.
both customer and frontline pain points. Frontline pain points are employee pain points. And it's not just the board treating it that way. The employer did. Employer managers, their own representatives, and T-Voice representatives all understood that they could raise any pain point under this program.
Is that right? So just as a matter of semantics,
Yes.
frontline pain points, as the board understands it, by definition, are CSRs raising questions about their own terms and conditions?
Absolutely.
That's
And
not what you said in your brief. You said that the program, the T-Voice, exists to enhance uh, customer and frontline experience by identifying, discussing, communicating solutions for roadblocks for internal and external customers. Don't say anything in there, in your brief anyway, that about enhancing the experience of employees.
Well, two things, Your Honor. One is, as we discussed, frontline means CSRs. I would say internal customers likely means employees too, but I'm looking at the record as a whole. How did the employer run this program? What did it encourage employees, and in particular, chief waste representatives to do? It encouraged them, this is the undisputed testimony, to go out and get all pain points. This was understood, including by the employer, as getting employee pain points as well as customer. They claim they stopped doing the latter at some point, getting employee pain points, but I don't think it's really disputed or not reasonably. The charter encourages the chief waste representatives and employees to bring forth complaints about their own working conditions. And if I
So,
may,
and are you looking at just, it would be helpful if you'd look specifically at the charter and tell us exactly what you're relying on. So,
well, I'm relying on the charter and how it was understood and expressed in the testimony, meaning that's what happened on the ground. As the board noted, it's undisputed that the employer's agents.
How do you know that any one of the employees in the 6 instances were invoking the charter? How do you know that? There's no evidence that I've seen indicating that they were invoking the charter at all.
Well, I see, Your Honor, but a couple things. I mean, as was also discussed this morning, in establishing a labor organization, we're looking at both the purpose, as you noted, the act says, for the purpose in whole or in part of dealing with the employer, but we also look at what actually happened. And here's what actually happened. After setting up an
The
organization.
statute tells you to look at the purpose. Doesn't say anything about anything else.
Well, the case law says both the purpose and what the organization
How it's
actually does.
operated is evidence of the purpose. Is that the idea?
I think what happens is evidence of the purpose. I think both are important. But what I'm trying to say
Is that a preponderance statement, a requirement? By a preponderance of the evidence that was operated to enhance the employees with respect to grievances, for example? Because if that's the test, 3,000 instances on one hand and 6 on the other, you'd lose.
Well, Your Honor, the question is whether the evidence shows a pattern or practice, both the purpose and what actually happened. And what actually happened is, first of all, T-Mobile set it up to work. They did say, you are representative. Go out, get your employees' comments, set up regular meetings where chief waste representatives were invited to come up with proposals, and then the employer accepted in a couple cases, and in other cases, considered or indicated it would consider those proposals. That is a pattern or practice of dealing under settled law. And my opponent cites no case saying 6 instances isn't enough. When you look at the cases they cite, one, purpose matters. There was one instance where it was unintentional. I have examples of an employer having a program for 3 years, which they said was not meant to deal with statutory conditions, and they slipped, or I think the board used the word straight once. That's not what happened here. This is the way T-Mobile set up the program and intended it to run. And 6 instances is enough. Now, the only way you get 3,000, I think that's a bit of a misnomer, is looking at SharePoint. But what the board's looking at is the meeting and direct contact aspect. The company set it up so you would have these meetings. During those meetings, there were multiple instances of proposals being made and accepted or considered, and that's dealing. If you take my opponent's approach and just say, well, we've got 2 aspects to this program. One might look like dealing, because they cite no case saying 6 instances aren't enough, but we can just wash it away or dilute it with this more ministerial SharePoint program, and we can wash our hands of it. I don't think that makes sense, because as we point out in our brief, then an employer could have something that looks like a program. I mean, looks like a labor organization that has dealing, 6 instances over several months in a manner that's consistent with the way the program's set up. That's dealing under settled law. That impacts employees. This domination of a labor organization is the most serious violation of 882, but then the employer could just say, well, we've got this other aspect. We don't think dealing happens there, so it's okay. And that's even putting aside, the board didn't address whether SharePoint itself involved dealing, because it didn't feel it needed to. It already had 6, or I prefer 8 instances of dealing over several months, and that's enough. I don't think 6 out of 3,000 is the relevant comparison. I think it's 6 intentionally over a period of several months. And my opponent cites no case saying that's not dealing. Now, my opponent, I just
Could
responded.
you just address the evidence of consideration? So obviously that's one piece of this. The other side obviously says you changed the test from acceptance or rejection to real or apparent consideration. But even if you're right on that, it does seem like you rely on things, for example, an email forwarding a suggestion saying, we will consider this in the future, or something to that effect. And I'm just curious, what is the board's position on what's sufficient? Do we need to think there was substantial evidence to find that later meeting actually happened and it was considered, and that's the finding we're reviewing?
Right. Well, Your Honor, I think it's first important in answering that question to go through all the evidence of acceptance and consideration we have that adds up to supporting the dealing, because out of the 6 or 8 instances, 2 proposals were accepted. I think with dual monitors, that's acknowledged, but also with the suggestion that we need a better script at one point to do our jobs better when we're talking to customers. The employer said, will do. We will update that to have a more realistic scenario. So we have a couple instances of acceptance. You have other instances where the employer indicated an intention to consider the proposal. Like they took actual action. They said, we'll consider this, we'll get back to you by the next meeting or sooner.
Well, that's my question.
Right.
Do we need evidence that they intended to consider it?
No.
Or do we use that as circumstantial evidence that they did
I
consider?
think it's circumstantial evidence they did. In fact, I would also say, if you take that specific action of indicating an intention to consider, and I promise you, I say, interesting proposal, I'm going to forward it up the line and we're going to get back to you by the next meeting or sooner, and you don't, that could be an indication of an implicit rejection, or if you prefer rejection by word or deed. It is not inconsistent with the rejection or acceptance standard, nor was the standard changed. The standard is actual or apparent consideration. That's from electromation. Even after cases like DuPont and others that also use the acceptance or rejection standard, a case like AFCO, both the board and the court, referred to actual or apparent consideration, proposals plus management consideration. And I think we have that here. We have a couple acceptances. We have clear indication of an intent to consider. And even if promised action of further consideration didn't happen, that appears to be an implicit rejection of the proposal. What it isn't, my opponent suggests, boy, we've gotten to the point of just passive knowledge of the proposal. Passive consideration, whatever that is, that's not what the board found. It identified specific action decisions by the employer. Again, a couple times accepting, other times specifically saying, we'll give that consideration back to you soon, and if they don't, I guess it suggests they decided not to go that way. But I don't think, as my opponent says, wow, we can no longer even tell what counts as a group proposal, because as Your Honor said, we can tell in this case, and T-Mobile indicated they could tell when they would say, accept proposal about dual monitors, and then issue a newsletter saying, great job by T-Voice. They weren't confused about whether it was a group proposal, and there's other evidence of that. I believe with some of the metrics proposals, there were instances where they said, we're going by the issue raised or other categories, not the individual. So unless Your Honor honors have further questions, I thank the court for this.
I don't think so. Thank you, Mr. Laro. Mr. Harris, we'll give you 3 minutes for rebuttal.
I want to make a few points. The first point is, Judge Garcia, to your last question about the 6 examples and the question of whether there was a flip-flop on the board's reasoning. One flip-flop that I've already identified has to do with, as we just talked about, whether or not what the purpose was of, excuse me, whether or not the proposal was considered or was not considered. But of the 6 examples, 4 of them concern a different flip-flop, which is whether or not these were employee pain points or whether these were customer pain points. And it's absolutely explicit in the original board's decision that the board deemed the device emulators, phone exchanges, device setup, and also the device insurance as all being customer issues, not employee issues. I won't read all the quotes, but it's absolutely crystal clear in the decision. I'll read one quote. This is from the board's first decision. The record does not indicate that T-Voice representatives were involved in this matter other than by entering suggestions into SharePoint. There is no evidence that T-Voice representatives discussed any employee pain point or idea to resolve a pain point at these meetings. The board has completely changed its view on whether something's an employee pain point or a customer pain point. And its rationale for that is, well, if it's a customer pain point, it must also affect the employees. But that's not the distinction that the board drew the first time. The board, on page 2 of its first decision, clearly distinguished between customer issues, called customer pain points, and a small number of employees' terms and conditions, which are called employee pain points. So that's another problem with the switch in their factual findings. Going back to the first issue we began with, which was representative capacity, I would challenge the description that this is characterization that this is an add-on. The board explicitly and deliberately chose to take this new approach and shoehorn it into the group proposal category. And that raises a fundamental question, which is what group are we talking about? Where's the group? There is no discussion anywhere in the board's decision about what is the group. If this is a group proposal, what's the group? The only group I can think of, which they don't say because they don't say anything about this, is that it's the group of that rep and that rep's constituents, the 10 or 15 or however many people it is. But once you say that, then it makes no sense that this is being charged against the entire organization, right? If Dominique Jones, on behalf of the dedicated care department, that group, makes a proposal, why do you disestablish T-Voice altogether?
How many regional T-Voice things are around the country? How many of them?
There are, I believe, there are somewhere between 10 and 20, changed over time, I think, call centers. There are something like a few hundred T-Voice reps altogether
All over the United States?
in these various places where they have call centers that deal with.
Is there any indication that in any of these 6 examples that there was communication between one regional T-Voice office and another?
No, absolutely not. In fact, the converse, which was that the board said the first time that there was no communication, there was no monitor, there was no screening, there was nothing going on. That's why the first time the board decided that T-Voice could not be held responsible, that this was a group proposal, because there was no evidence that T-Voice has had anything to do with what individual representatives were proposing. The board hasn't moved off that. They've just changed the definition of the group, and they're hoping that by this switcheroo, it'll be attributed, this group is that group, but they're not. One final point I'll just mention, sorry, I know I'm out of time, is just that I've heard nothing from the board at all to explain the passage between 2016 and 2023. The board made explicit findings in the decision that employee pain points were no longer considered after February 2016. It's in their brief, on the brief on page 55, I believe on page 7. So why is it being disestablished? They just don't have an answer for that. The board has no further questions.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.